Start. The learned counsel appearing for accused Vijay, in support of the appeal, urged that on the same evidence, there are two judgments of acquittal in favor of the accused. Stop. He submitted that even in the appeal against the first order of acquittal, the High Court did not convert the order of acquittal into conviction and passed an order of remand. Stop. He submitted that the finding recorded by the High Court was that on the date of occurrence of the alleged offence, the prosecutrix was more than 16 years old. Stop para. Section 375 of the IPC, as was applicable on the relevant date, provided that consensual sexual intercourse with a woman who was more than 16 years old was not an offence. Stop. He invited our attention to the finding recorded in the impugned judgment by the High Court. Stop. He submitted that the High Court held that the prosecutrix willingly accompanied accused Vijay, who was sitting beside her in the video parlor where the prosecutrix was watching a movie. Stop. He pointed out that the High Court held that the prosecutrix had acquaintance with accused Vijay, and he had shown interest in solemnizing marriage with her. Stop. He submitted that even going by the case made out by the prosecutrix, she walked ahead of the accused Vijay and reached a bridge in the town. Stop. Thereafter, accused Vijay, along with two other accused, came there. Stop. Her evidence shows that she had several opportunities to raise the alarm but failed to do so. Stop. He submitted that the evidence of the prosecutrix cannot be believed considering her conduct. Stop. He submitted that the Sessions Court, on two occasions, acquitted the accused after making detailed consideration of the evidence on record. Stop. He pointed out that after the remand, the Sessions Court, after considering the evidence of the prosecutrix, concluded that there were contradictions in her testimony, and she made improvements. Stop. Moreover, her conduct on the date of occurrence does not support the theory of sexual intercourse without her consent. Stop. He submitted that the High Court should not have interfered only because another view was possible on the same evidence. Stop. The learned counsel appearing for the state urged that the judgment of the Sessions Court, after remand, is perverse. Stop. He submitted that no reasonable person, after reading the testimony of the prosecutrix, would conclude that the sexual intercourse was with her consent. Stop para. Submitted that the approach of the trial court while dealing with such a serious case of gang rape was entirely uncalled for.